Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to Massachusetts. Massachusetts, however you want to say it, so here, not the most groundbreaking decision, but it is certainly interesting. You had a very well, I think we talked about it, or you spoke about it, a civil service exam, which was denied basically to be, or the exam was thrown out because the results were discriminatory, right, against minorities. And so
if you want, I'll take the lead because I'm pretty familiar with this, and this has been going on for a while. But first of all, let me say, if you're not from Massachusetts, don't do what Massachusetts does. Okay. Massachusetts has this wonderful statewide civil service system, which in some ways is good because it takes the burden off the local fire department to come up with your own exams, but you're giving up so much by letting the state run your promotional system for you. Okay. But at any rate, we have a civil service exam that was supposed to take place in, I think it was March of 2022. The individual is a captain with the Boston Fire Department, and he would have been ineligible for that exam. The city, for whatever reason, it wasn't clear to me, but the city postponed the exam once. Okay, and they rescheduled it for November. He still wouldn't have been eligible because he was a lieutenant. He had just made captain. So and as a captain, he wanted to sit for the district chief's exam. And I think he had about a year or so as a captain, and I think he needed to get to 2 years or whatever it would have been. Bottom line is he's not allowed to sit for the exam. Now there's a court ruling that strikes down the way that the mass civil service system has been developing their exams and their use of multiple choice exams. So you have this case, the case is Tatum versus Commonwealth of Massachusetts. Okay, so that case basically puts the civil service system back on their heels. They have to postpone, cancel all of the exams. They got to go back to the drawing board and come up with a new exam process that is not going to have a disparate impact on minorities. Okay, so now the Boston exam, this district chief's exam, gets pushed back, and it's rescheduled for in a couple of weeks, March 25th of this year. At that point, the captain would be eligible. So now, once they announce the date, he puts in for the exam, and they tell him, "Sorry, you can't, because we're only going to let people who were eligible for the exam a year ago sit for the exam." And he said, well, that's not fair, because the people who were eligible then, some of them have retired, some of them have moved on. Now there's a smaller pool, and I'm being denied the opportunity to test for that position. And by the way, the civil service regulations say I have a right to it. So he filed the suit. First of all, he went through civil service and they turned him down. So he filed suit and asked the court to allow him to be able to sit for the exam. Okay. And I don't know if you want to.
Sure. I mean, the court goes on and says, listen, they recognize it's unfair, right? Could be unfair, but basically they said, he wasn't eligible at the time, so we're not going to allow him. And this was a mere rescheduling. But the decision was, or the question was, whether it was arbitrary or capricious. And they cite the government's reasoning for limiting who could sit for the exam to the original qualifications. And they said, listen, that wasn't arbitrary. It may not be right, but it's not arbitrary. That's a tough standard. They also noted that he wouldn't have been eligible, right? They went through, he wouldn't have been eligible anyway. So it didn't really matter. But again, a government's decision, so everybody knows when you're challenging it, because this is going to lead right to the next case, the FDNY case we're going to get to, is whether their decision is arbitrary. Sometimes it's whether it has a reasonable or rational basis, right? They just have to have a good reason, basically. And it doesn't have to be the best reason. It doesn't have to be as long as a reason, a valid reason, then that's enough. Maybe there was a better way to go, but that doesn't matter. It just has to be rational. And so it's a very tough standard when you are challenging a government's action. And that's a nice transition to our next case, if you want to end there, unless there's something more you want to say.
No, no,
Okay, let's go.
this Mass Civil Service case resonated with me as someone who, I mean, I spent a lot of my time when I was with Providence studying, and I know for the folks out there that have to do that, you study for years and years and years, and even moving an exam a couple of weeks to a couple of months can change how many points, seniority points, and different things folks are going to be able to accumulate eligibility. And so I can understand a judge not really appreciating just what goes into the overall process. But at the end of the day, the way that it was interpreted was the civil service regulations give the Civil Service Commission some discretion. And that
broad
discretion
they said, broad discretion.
A lot of discretion, as long as the decision is not arbitrary or capricious. And capricious would be, for example, if someone involved in the Civil Service Commission's relative was in a position to benefit from the decision. Now we've got some different questions that come up. But other than that, other than something like that, they have the discretion to make that kind of decision.